I'm going to call the meeting to order. First, have a pledge to the flag, please. Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. In attendance, we have Russ. I don't know your last name. Russ Lagra, David Bouchard, and Craig Shackness, which is a quorum. There are 5 members on the panel, and 3 are here. Do we want to review the minutes, or do you want to can I have a motion to approve the previous 5/27 minutes?
Motion to approve the minutes.
Any discussion?
What?
Any discussion on the 5/27 minutes? All those in favor of approving those?
Aye.
3. Okay, new business. This is a public hearing where Energy North, represented by Archipelago Law, has filed a second administrative appeal for relief from the decision of the Planning Board on April 15th, 2025, to approve the C.M. Brown site plan for a 5,000 square foot convenience store and associated improvements located at 99 Roosevelt Trail, map lot U06-07 and 08 in the commercial zoning district. Was the application received in a timely manner?
Yes, it was.
Okay, very good. Do we have, do either parties, CN Brown or Energy North, have any questions regarding the jurisdiction of this Board of Appeals to adjudicate this?
No, we didn't. And no from C.M. Brown.
Okay, very good. Does Energy North want to address their standing?
Thank you, members of the board. First off, my name is Michael Skolnick. I'm an attorney with Archipelago, permitting attorney. I haven't been intimately involved in this appeal or the planning board process, but I'm stepping in here tonight for Keith Richard, who has a family issue down in Massachusetts he had to attend. So bear with me if it takes me a second just to follow along, but on this threshold issue of standing, we really feel that last time we were in front of this board for almost this same issue on a different site plan approval, the parties' positions really haven't changed here. This board found that there was standing. Both the positions of the parties haven't changed. There's a site plan approval. We're in this exact same locations here. We are abutters as the law court defines a butter. Your ordinance specifically, at least in your notice of decision, the last one that was issued by this board, it recognized that your ordinance says appeals are available to abutters and other aggrieved parties. Abutters here is defined by the law court. You use that precedent that's been set, that's close proximity and within the neighborhood. And those are those 2 key terms that we're looking at here. We are in close proximity. You found that last time we were in front of you. That has not changed. You're within the neighborhood. The law court looks at potential zoning districts and things like that. We're in the exact same zoning district as the proposed project that was approved by the planning board. There's nothing that's changed here. Standing hasn't changed at all. They may point to a different definition that's been added to the zoning ordinance, but if you look at the law court's precedent that's been set on exactly what standing is, we're in the same position as we were beforehand.
Okay.
And I'll address anything that CN Brown has to say as well.
All right.
Jason Dennis from Hastings Law Office, and I will be brief because we maintained at the last hearing that Energy North did not have standing based on their distance and no actual injury to their property and no real injury to them at all. And we maintain that this is a sort of a competitive business decision to follow through with this second appeal. Well, the first one too, but the second one. A couple things have changed. One being the definition of a butter in the Town of Naples ordinance that was alluded to by counsel for Energy North. But what's different this go-around than was the last go-around is Energy North did not actually participate in the planning board hearing. They may have been online, but they did not show up and participate in the hearing, which when courts are looking at it and boards are looking at it, the participation is one of the things that is looked at. So they did not participate the second go-around, didn't raise any arguments because they spoke not at all.
So when we remanded that back to the planning board, they did not participate in that?
There were two. We had two hearings. One was a scope hearing because of the nature of the remand/reversal. There was some confusion there, and so we had a preliminary hearing to determine what were we going to talk about when we got into the meat of it and the merits of it. And so Energy North did appear and speak and present through counsel at that hearing, which was, I believe, April 1st. At the subsequent hearing, which was the heart of the matter, the merits of the site plan application, April 15th, I believe it was, they did not appear in person. Again, they may have been online, but I could not tell. But they did not make any comments of any variety for or against and make any arguments. But the definition of a butter has changed. And the law court does talk about the neighborhood and proximity, but it also does defer to towns' own definitions. So towns can delimit their sort of a butter status to some extent. They couldn't, statutorily say it's just the next door neighbor and nobody else, and you pick one side and those kinds of things. You can't shut it off so extremely. But there is some deference to that. And so the definition has changed such that an abutter in the town of Naples is a common boundary owner or somebody within 500 feet. We know that the appealing party here, Energy North, is not a common boundary owner. They are approximately 6/10 of a mile away, which, if the math matters, it's approximately 3,168 feet. I did that math, which is 6.3 times further than the 500 feet. And so we believe because A, they did not participate to sort of get their foot in the door in that way, and the definition of a butter has changed. In addition to everything that we had said the last time, we think that those two pieces, the non-participation and the new definition of a butter, take it over the edge, so to speak, from whether it was a close call or not. I know last time there was a little bit of a struggle on the board to define what the neighborhood was to see if it fit within that. And so in that instance, the neighborhood was defined as the entire zone, which C. Brown did, in fact, appeal that to the Superior Court and to preserve that issue depending on how things went. And obviously here we are, again, still trying to get this thing off the ground. But so that has been appealed. We do, with respect, disagree that an entire zone, especially one of this magnitude, would qualify realistically as a neighborhood, so that every single possible business and residence would therefore be in a butter. And I think the definition addresses that. And so because the definition has addressed that, that would change, from our perspective, should change this board's neighborhood analysis, such that since they don't meet any other standing criteria, they now, considering that the town through its governing and legislative bodies have decided to delimit it, no longer are within the neighborhood as defined by the town itself. And so for that reason, do not have standing the second go-around.
Ben, the appeal was filed before that vote was made, correct?
Yeah, do you want me to come up? I can.
If you would, please.
Yeah. Just so everybody can hear me, I'm Ben Algio. I'm standing in for Amy Chow, who's the town's attorney. I work with Amy, and I've been following this case since the beginning and the case that came before it. On the issue of standing, so your ordinance says that only a abutting landowner or an aggrieved party may challenge a decision of the planning board to the Board of Appeals. And so the parties are kind of arguing about whether or not Energy North is an aggrieved party or an abutter. You'll recall the last time that this came up, you decided that they were an abutter because they were in the commercial zone on 302 within a minute drive of each other, and you said it was a close call. C. Brown has raised a couple of arguments here tonight on why you should change your mind on that. So the first is this new definition of a butter that has been adopted into your ordinance. My understanding is that's correct. I haven't actually seen the new ordinance, but I also understand that adoption happened after this appeal was filed, and under Maine law, a change to an ordinance does not affect any pending proceedings. So this is a pending proceeding for that purpose, and the new ordinance definition shouldn't be applied in this proceeding, is my opinion. The participation argument that C.N. Brown raised here, basically saying they don't have standing because they didn't participate enough in the planning board proceeding below. That's usually a requirement to have standing to go into court. There's no similar requirement, as far as I can tell, in your ordinance that somebody participates below. And in any event, it does look like they at least submitted a memorandum to the planning board addressing the issues in this appeal. So I would say, to the extent that is an issue, I think they have met the participation requirements. And if they participated in an early meeting, and if they participated on Zoom, generally that's enough, even to get standing to go to court. I think it's probably enough to get standing to go here. So in summary, I don't think anything has changed from your last decision that would merit a change on the standing issue, at least not legally, but it's your call.
Okay.
Any questions?
Questions? Do we need to vote on standing?
Yes.
We do?
Yes.
Okay, so do we have a motion from the floor to approve standing as we had in the previous meeting to apply in this meeting today for their appeal?
I'll make a motion to approve the standing.
Okay.
Second.
All right, any discussion?
Second.
Second. Any discussion? Okay. Vote to approve? Approve. All three in favor? All right. So next up would be Energy North. If you want to go through your points of error and the appeal?
Sure.
Okay. Oh, you have a
If I
question?
may, I apologize, as a point of order. I think there was some conversation of another preliminary issue, which is I'm sorry?
Cover the microphone, sorry.
Yeah, it's really hard to hear tonight because the AC, so
Oh.
let's speak up a little bit.
Sure. Another preliminary issue
Yeah.
that we had addressed with the board's counsel for this evening to discuss sort of as a threshold before we get into the merits of it.
Got it.
Is, it's a Latin term, it's called res judicata, and it is a,
I took French.
it's a legal issue, and so obviously your counsel can advise you one way or the other on that. But the issue in a nutshell is, and it's ironic, I guess, in a way, since we're dealing with a Big Apple store, is that the legal principle of res judicata, which is Latin for literally thing judged, or judged thing, is the legal principle that stands for the idiom, you should only get one bite at the apple. And with regards to the points of error that this board has already heard and decided on, we are here today for many of the exact same things. There's one definitely new issue, and so this legal doctrine principle would not possibly apply to that because it's brand new, which is the Class 3 buffer requirement that was waived. There's another that's sort of on the fence, which is the driveway width, because it's a different driveway width now, but now 40 feet is also apparently not good enough either. But the argument for the 40 feet not being good enough is the exact same argument. Because the 42 feet not being good enough the last time was because that exceeded the town's limit. The 40 feet is the same argument as it included in the last appeal, because they said 40 feet is a state requirement. You need to meet these, which they've met because they've got the permits in hand from the state for all the driveway stuff. So the res judicata argument, we know we've heard the same arguments for the internal markings and all those things. There are 5 requirements, and I'm going to quickly go through these. And this comes from court's wording, not mine, so my apologies if it sounds a little overly legal-like. Some won't. But one is that there was adequate notice of the proceeding. 2 is that the right to present evidence and legal argument existed, and the right for the opposing party to rebut the other side. So each side gets to make arguments and oppose the other. A formulation, this is the one, a formulation of issues of law or fact to apply rules to specified parties concerning a specified transaction, the rendition of a final decision, and any other procedural elements as may be necessary to constitute the proceeding a sufficient means of conclusively determining the matter in question. There's no doubt that there was, and I don't think there could be any argument that there was adequate notice of the prior Board of Appeals hearing when we're all here. That leads right into number two, we all made our arguments. Energy North made its arguments, C.M. Brown made its arguments, we both opposed each other on different things. Board had counsel that discussed those things. And so that right was there. Third, the formulation of the issues was quite clear and obvious because both entities were represented by legal counsel, and the board was represented by counsel that helped navigate what all these legal and factual questions were. So they were all fully vetted, formulated, discussed, and decided. And that decision was, we now know, I think, from the Superior Court, a final decision. And we know that because Energy North filed a motion to dismiss C.M. Brown's appeal. So I mentioned earlier that C.M. Brown appealed the issue of standing. So that is currently pending as an ADB appeal in Superior Court. Energy North filed a motion to dismiss that on the basis that we did not yet have a final decision, and ADB appeals should only be of final agency or municipal decisions. The Superior Court denied that motion to dismiss on the conclusion that we have a final decision and we can therefore go forward with the ADB appeal, which is sort of concurrently pending. Nothing has been briefed and no court date has been set to argue that. But the Superior Court, in denying Energy North's motion to dismiss, said we can go forward because this was a final decision. And then fifth is any other procedural elements as may be necessary to constitute a proceeding, the proceeding a sufficient means of conclusively determining the matter in question, which those issues were discussed here, vetted here, counsel made their arguments, advice of counsel, there was the question of reverse or remand. There was a reversal. In fact, when we argued to the planning board that the class 3 buffering requirement did not apply, because from our view, similar to the standing thing we just talked about, it's all one thing, it was a pending proceeding. Advice of counsel to the town was that it was not a pending proceeding, and so the class 3 buffer had to apply. And so if it was not a pending proceeding then, it was done. Final. And so the law court says that this doctrine applies equally within the municipal context if the criteria are met. By way of one example, I think out of North Berwick there was a case. In that case, the aggrieved person did not appeal it to the Board of Appeals. So they had a planning board decision, so a municipal board decision. They had the right to appeal. They didn't. And once their appeal period passed, it was final. Here the difference is, they did appeal here. Energy North had the right to appeal, just as C.M. Brown did on the standing issue, the right to appeal to the Superior Court your decisions rejecting all but one of their points of error. It did not. That period has lapsed. It is final. So here today, they are trying to get a second bite at the apple, or the big apple, and the law, res judicata, says they should not do that because we favor finality in legal proceedings, so we're not going back 2 and 3 and 4 times. So that's the legal argument on that. We would hear the class 3 waiver argument, and we can talk a little bit more about the driveway width argument, but I would submit to the board that that is foreclosed too, because the only remaining argument is the 40 feet state argument, which was made before.
Okay.
And I can answer any questions or respond after.
Yeah. Please.
Thank you. I want to point out one thing and make it very clear that this is a separate application, a brand new application that was approved by the planning board in front of the board. It was not a remand from this board back to the planning board on the same application. There were changes to the plan that were not on the plan beforehand when this board had an opportunity to review that prior site plan approval. Those changes are addressed in some of those points that council claims are barred, let's just call it, instead of saying res judicata over and over. This is a new application and a new approval. There are new issues here. There are also new striping that was addressed that they claim can't be brought up and considered by this board. We have to consider it. We have to preserve those things for a potential appeal to the law court later on. The notice of decision that I saw didn't quite get to the merits of many of those issues, those DOT issues, let's just call them. And those were about sections 1 through 5 of the letter that was submitted to you by Energy North and Attorney Richard. Those issues, they're DOT issues, and it's an issue of preemption, pretty much. Can the state approve something that is not allowed? Can the town approve something that was not allowed by the state? We have to consider that. What the notice of decision said is if the entrances are approved by the state, then the permits will issue that the planning board previously approved. It didn't get to the merits of those issues, and therefore it wasn't decided. All we simply want to do here is preserve them before this board, have a decision made, and then we can determine what we want to do later on. I wasn't privy to the 80B appeal that has been filed already. My understanding of it, and I hope the town's attorney can correct me if I'm wrong, is that it was an appeal of standing. This board said that Energy North did have standing, and they appealed that decision. It wasn't an appeal of all of these other issues. So simply because it's in front of that court doesn't mean it shouldn't be addressed by this board right now. I also do think if we don't get to the merits on some of these issues, it's simply only going to delay it further if we have to appeal the res judicata issue to the board, to the courts, and then it would have to come back to this board if Energy North were to prevail at the court level. If we don't hear these issues, just like if we didn't hear standing tonight and you folks made a decision on it, would have to go to the court for an appeal and then have to come back here for the merits if we were to prevail. There's no reason to have that. If you folks can just hear all of the issues tonight and make a decision on that, this can all go to the courts one fell swoop instead of having this extended, and obviously I know everyone doesn't like how much this has been extended out so far.
Hello again. So just to be clear about the issue that's being teed up here, what CN Brown is arguing is that you are legally barred from making a different decision on the points of error that Energy North raised that it had also raised in the other appeal. And they are, I think, reciting the kind of standard correctly there. The one piece that I think is not present here, and I think Energy North did touch on this, is finality. The agency decision is still under your original decision on the other application is still under appeal in Superior Court. If the Superior Court decides that CN Brown is correct and that Energy North didn't have standing to bring that first appeal, the whole decision is out. And so you don't have that element, in my opinion, and this is a little bit of a nuanced issue. The cases are not super clear on this, but I think the way I see it, you don't quite have finality on that first decision yet. And so my secondary advice to the board on this is if you make a different decision where the facts are the same and the law is the same, it could be seen as like an arbitrary decision making. So even if you're not legally barred from making a different decision, I wouldn't recommend where there hasn't been a change of facts and a change of law. So that's my kind of quick and dirty on that. Do you have any questions about?
And my question is, if there's nothing different in 5 of the 7 items in here, do we need to discuss them each individually? Can we group them together and say these were previously decided at the previous meeting on January, whatever it was?
I think you could make a motion to that effect and vote on it. Yeah.
Okay.
Yep.
So, just so that we're all clear, the things that are a repeat from the 1/28/2025 meeting are the points of error cited by C.M. Brown in their document. Would be point number 1, point number 2, point number 4, point number 5, and point number 6, correct?
That's right.
Those are what we previously voted on, correct?
Yes.
So can I ask for a motion from the members
Yes.
for those items?
Well, I wasn't even here.
That these have been previously, it has to come from you guys, but, that they've been previously decided. And we would rather entertain the new items, which would be point number 3 and 7. Can you state that for the record? David?
Okay, I move that we move forward with just the new items that haven't been approved in the past.
Okay, so the ones I just mentioned.
Yes. All the
All
ones
right,
you just
and
mentioned.
only consider the new ones, which would be 2 and 7.
Right.
Second.
No, 3 and 7.
Second.
Okay, any further discussion?
No.
Right. All those in favor? 3-0. All right, so I would invite Angie North to come up and please only address 3 and 7.
Thank you. So I touched on this principle earlier, and this principle, it's really an underlying principle in this whole entire appeal. It's that municipal approvals can't preempt minimum state standards. That's true with DOT, that's true with DEP, shoreline zoning, and many other state regulations that we have to follow. Even if it's not incorporated into the ordinance, the DOT rules expressly state that the more stringent and restrictive requirement as it relates to the purpose of the rules will apply. If there's a stringent requirement, such as driveway width, that has a state standard, the town cannot approve something that is wider. That's just an example. I know we don't want to go through all of the things, and we made a motion for that, so I do want to address driveway width in particular. That's item number 3. The DOT establishes a maximum width for two-way entrances of 30 feet. I know at earlier appeals it was considered 40 feet. However, the actual standard allows an increase of a maximum of 42 feet, but that's only in certain circumstances. That's where it's found that 30% or more of the traffic using the proposed entrance will be larger vehicles. Before the planning board, there was absolutely no evidence admitted into the record. There was no findings, anything to support that 30% number. It can't be increased over 30 feet unless the planning board found that 30% is met. There's been no evidence of that. The proposed entrances are 40 feet wide. Therefore, the approved site plan, what they're doing is preempting state law. It says 30 feet, they're approving 40 feet wide entrances. That's not allowed. Therefore, this board should do exactly what it did last time and reverse the decision of the planning board. Have them come back to the planning board with a plan that meets state standards. I know we're skipping around here a bit, but the real crux of what is new in this appeal, I do want to address one thing. I do think item number 6, the traffic patterns, there was different traffic patterns presented on the new plan. I believe there was a crosswalk added to it, and however, there are certain things that are not on it, like directional arrows, that need to be there. This is a large site, there's tractor trailers coming through it, there's everyday traffic as well. The fact that there's simply extremely little directional arrows and pedestrian circulation signage, it's an issue for this site.
To make a
I was going to say, I would ask you to confine your comments to items 3 and 7.
Absolutely.
Yeah.
Item number 7 is the buffer standard. Between the original site plan approval, this board's reversal of that approval, and then the new approval that's up on appeal here tonight, there's been a buffer standard that was added to the ordinance. What that says is it requires proposed developments to implement a Class 3 buffer where a commercial use abuts a residential use. The purpose of that is to separate incompatible uses. Right in the ordinance where it says this at section 908(2)A, for Class 2 standards, it specifically says incompatible districts and incompatible uses. It tells us that the purpose here, the whole reason that the town implemented this ordinance amendment is to separate incompatible uses. There's no dispute here that this is a commercial use abutting a residential properties. Absolutely none. However, what they do propose is not to meet that Class 3 standard. Instead, they're going to implement a Class 2 standard, which is a substantially lesser buffer between the two uses, the two extremely incompatible uses. What the planning board did is they granted a waiver of that standard. The site plan review ordinance has specific criteria that you have to meet to grant a waiver. And when you read the findings of fact from the planning board, you can tell that they know what those are. Absolutely. It really says special circumstances and unnecessary burdens, which is the fourth prong of that test. It pretty much says, it has a sentence that says there are special circumstances and it's not going to affect the neighboring properties. What it doesn't do is make any findings about what those special circumstances are and why compliance imposes any unnecessary burden on CN Brown. Why doesn't it have it? Because there was really no discussion about it at all. What they're asking for is a lesser buffer between two drastically incompatible uses here. However, they have no special circumstance. This is a gas station that wants to go in next to residential properties, and they specifically said, their engineer said at that meeting, I believe it was that the buffers were not provided, and I'm paraphrasing here, because it would interfere with their preferred layout. Because they didn't want to. That's why. Because it worked better for them if they had the layout that they presented to the board. That's not a special circumstance. That's not an unnecessary burden for them to engineer a site plan that actually fits the ordinance. Instead, they say, let's implement a lesser buffer in people's backyard, or just abutting people's backyard. That's not meeting the waiver requirement. And since I'm not going to discuss any of the other points, I'd be happy to address any questions that you have or answer any of CM Brown's comments as well.
I don't have any questions.
Number three was the width.
What's that?
Number 3 was the width,
It was the width.
and 7 was the buffer. Okay.
7th buffer zone
Yeah.
from 2 to 3.
Yeah.
CN Brown?
3 to 2, actually.
We'll address the driveway point of error first, and I will do that in two ways. One, which is to go back to what I had said before, is that we believe that that has actually already been addressed by this board before, and I'm going to reinforce that point by reading from the appeal document from both times. Let me just get to it. The driveway width is inconsistent with DOT regulations which apply to this project and control. DOT establishes a maximum width of two-way entrance at 30 feet.
Could you
DOT
speak up a little?
Yeah. Is it for, okay, I didn't know if it was for the audio or the actual, so,
Unless you're gonna sign.
sorry, Mr. Leshua. The driveway width is inconsistent with DOT regulations, which apply to this project and control. DOT establishes a maximum width of a two-way entrance at 30 feet. DOT standards allow an increase up to a maximum of 42 feet, but only where 30% or more of the traffic using the proposed entrance will be larger vehicles, i.e. trucks. That's the current one. The previous one was, the driveway width is also inconsistent with DOT regulations, which apply to this project and control. DOT establishes a maximum width of a two-way entrance at 30 feet. DOT standards allow an increase up to a maximum of 42 feet, but only where 30% or more of the traffic using the proposed entrance will be larger vehicles, i.e. trucks. The reason the word also was removed this time around is because we became compliant with the town's ordinance by reducing it from 42 to 40 feet, which was the entire reason we went back to the planning board in the first place. And in fact, the discussion about what we were going to do there really is, I think, overall important to the sort of fundamental fairness aspect of any proceeding. The original idea was that it was going to be a remand just to address that issue. And that was sort of how we were headed. There was then some discussion and comment from council to the board, and through comment and discussion from council to the board, it became a reversal. However, it was still apparently not super clear, because in Energy North's motion to dismiss that they filed in the Superior Court, they themselves, in that document that they filed with the court, signed on behalf of their client, referred to what was done as a remand back to the planning board. Not a reversal. That was the basis of their argument, because they were saying it was a remand, it's not final, therefore you have to dismiss this appeal before the Superior Court. That is what they argued to the Superior Court, and now the issue has been decided by the Superior Court. It was a final decision. It was not a remand, it was a reversal. But I just wanted to clarify that for the record. And additionally, I just take this second to clarify the record that the only things added to the new site plan were that the driveway was changed from 42 to 40 feet. And then there was some additional buffering added. And I'll get into the buffering. Obviously not class 3 every single place along the site plan, but those are the two changes if we're thinking about sort of.
So semantics is everything here.
Semantics is often a big part of what
You do.
people like me and your council and Council for Energy North do.
So
And it drives some people crazy, but we love it. So I apologize that is sometimes what we deal with is, there's a famous case that where the comma was decided the entire outcome. Luckily, we're not quite that nuanced and crazily subtle and picky today. But the point with regard to the driveway first is that it was in fact argued to this board, and that piece was rejected. Part of the reason that was rejected, and so this leads into the second piece of the argument, is that the planning board did not preempt or try to preempt state law or step on DOT's toes, because it was a conditional approval that said, okay, fine by us if you get what you need from the state. So the state was ultimately in charge of that. And so out of one side of the argument is you can't do that, but the other side of the argument is, but you didn't have any findings for having done the thing you can't do, because the 30% piece is a state piece. So Energy North is saying you can't do this, but you should be reversed because you didn't have any findings on the record for the thing you cannot do. And C&M Brown has the permits they need from the state. So the state, whether there was the possibility of preemption, I guess, because the planning board decided something that the state wasn't going to approve, which there wasn't because it was conditional, meaning you're not going to get a final approval from us unless the state steps in and gives you what you need. So then it never really was. But even if there was, it was cured or fixed because the state, through the DOT, gave the TMP, the traffic movement permits for the driveway. So that issue is, it's a non-issue. It was decided before because, again, it was the exact same argument with regards to the state's 30% piece. But the preemption argument, that shoe just doesn't fit because the state ultimately is the one that issued the permit.
And the planning board has the authority to grant that waiver for the driveway width.
So they, they didn't grant a waiver in the truest sense, like they did from the 40 to 42.
Right.
They said, we approve you at 40, which is our requirement,
Right.
subject to, so if you, I guess you could think of it as a waiver, but they didn't say you can do 40 no matter what, so we're waiving it. They said you can do 40 because that meets our standard at the speed and sight distance.
Right.
I'm sorry, that's a different argument. I don't know why the old things are coming in my head. But you can do it because it meets our requirement, 40 feet.
Okay.
And it's conditioned on getting the approval
But
from the state.
ours was 42, and we're.
At the first time, well, let me back up. So the Naples ordinance max
Yep,
is 40.
40, and they want
The
40.
state max is 42. So last time we were here, we were at 42. And the argument was, regardless of what the state has said or done, and whether you have any state permits, you can't exceed your own ordinance. And so now it's kind of a little bit different, because regardless of what you want, you can't exceed the states. So we're at 40, which is what was the decision from this board previously. Go back to get the waiver at 40, not 42, and so the site plan reduced the driveway width from 42 to 40 feet,
Okay.
acting in reliance. I guess I should put that buzzword on the record, acting in reliance on the conversation between the town's council and the board's decision, which is go back. And the actual words that were used in the comments from town council to the board is the same application.
Okay.
So that's why there were not significant changes, because C.M. Brown was going back to deal with just that issue. Was buffering added where it could be because this issue was out there with Class 3 and we had that scope hearing on first as to whether that would or wouldn't apply, and we'd had a decision on that, so we had to address that the best we could? Yes. But we went back to the planning board based on advice of council and this board's vote to address the 42 feet. And we did so by narrowing it to 40.
Okay.
And the state has approved of that. So because of that, the planning board didn't take any power from the state. If the state hadn't approved what the state approved and provided the TMP, the traffic movement permits and the necessary permits for the driveway to C.M. Brown, then there would not be an approval, because it was conditioned on that. So it just wouldn't be a final approval. It's only final because the state gave its blessing too. So sorry that that's a little convoluted and confusing with the 40 and the 42 and
You want to move on to
everything else.
7?
I would love to move on to the next one, which is the buffering. So that's another quirky one because of this fundamental fairness idea that we are here, we're at this board. The vote was going to be a remand for driveway, it became a reversal for that with the same application, and so we presented the same application. When the issue came up sort of in April 1st and the decision was made that no, the buffering will apply, that was added to the site plan where it could be done. The planning board listened, including to an abutter, by the way, and I think there's an abutter here, if you're going to take any public comment, who spoke to say that I, as the actual true abutter here, can't wait for this site to be improved by C.M. Brown, and I have no issues with it. And so that, in the overall picture, I think is important. With regards to the findings of fact, first of all, during the hearing, there was a question from the planning board at the 1 hour, 16 minute, 45 second mark. That was, so is it the fact that the layout and the design of your site with parking and circulation, etc., prohibit meeting the Class 3 buffer? And C.M. Brown's response to that was yes. Now, part of that is, of course, because as a property owner who buys property and wants to make a practical and effective, economically viable use of it, you maximize space where you can for the fueling stations and the Big Apple store. So that is a part of it. There was a gas station there previously, by the way, so they're not coming in to knocking down 3 residential homes and plopping up a gas station. So it's a performance standard, so it can be waived. There was an argument that the planning board didn't even have the authority to waive this, but there was no support for that. I didn't hear that today. So the planning board certainly can waive performance standards. And again, there's a equitable estoppel argument here when we are told to go back for driveway only, and I say I don't have stock in C.M. Brown, but when C.M. Brown is told to go back to deal with the driveway issue, and they do that, they spend the time and the money on the site plan, and then have to deal with the buffering, that's an unnecessary convenience. So it's two things. It's the time and the money for the site plan process. It would then, three things, the time and the money then for the extra work done for the buffering, and then the loss of the square footage from going to 25 to 50 feet for that buffer, which then diminishes the return on investment of the process. There's also the idea of whether it sort of meets the spirit of the site plan review and there's any negative impacts to the town or abutters. We know that there's not, at least from the one abutter that has shown up multiple times to speak in support of the project. But we also know, because before the Class 3 buffer was approved, after the first planning board hearing, additional buffering was added, but exactly as it was before without the additional buffering was approved. So nobody argued against it, including Energy North, to say, well, yeah, I know there's only this requirement, but really it's problematic for these other reasons. So it's been approved. The legislative history, so to speak, of the amendment is interesting too, and I do want to briefly put that, at least just get that on the record, which is at the ordinance review meeting where it was discussed what the purpose of this was. The purpose was to create a buffer between, in the minutes of this meeting, residential and commercial districts. This is a set of residential uses within a commercial district. So really the spirit of this was to buffer, at least from what was said at that meeting by the folks spearheading the change, to have this buffer between the districts, not the properties. Because, I mean, you can imagine if somebody has a grandfathered residential home, they've lived there for their entire life, and a commercial district has sprouted up all around them, and they don't want to leave, and a new business comes in a totally commercial zoned area. You could have different opinion on whether, how much buffering we need. That person's, been there, and they have the right to continue to live there unless we take it by eminent domain or something like that. But this is a commercial zone. We are in a commercial zone. And so there is the argument that we've suggested that this buffering shouldn't even apply because the legislative history behind it says it's to buffer districts, not properties. So the unnecessary burden, I think I've mentioned this, is the time, the money, the loss of money, the inability to design this as it was already approved. And with regards to findings of fact, the planning board issues, let's see, I think 7-page document that goes through a number of the different, there's a lot to go through in the planning board process with the different criteria to check off. With regards to the buffer and landscaping, there's 1, 2, 3, 4 bullet points. Now, I'd love to stand up here before you on behalf of C.M. Brown and say there's 87 bullet points and they're all different facts that were found to support the waiver of the buffering requirement. I can't do that. But what I can tell you is that there was a finding that the applicant requested a waiver to allow for a Class 2 along McConkey and Graves property lines. And then the finding is a Class 3 buffer has been added where practicable. Thusly, it's not practicable to put it elsewhere. That is an implied finding as clear as you can ever say there's an implied finding. They found that the Class 3 buffer was put everywhere it was practicable to put it. The additional piece that is a part of the record is the site plan itself. The site plan itself shows you where the residential properties are and what the buffering is. And so C.M. Brown put the Class 3 buffering where it could, in keeping with the previously approved application, the same application that we were informed we could go back with after the last Board of Appeals hearing, which we did, unfortunate perhaps on some level that we added some class 3 buffering so that we could get this finding, but this finding from the planning board supports their decision. They found that this was where it was practicable. And so that's what C.M. Brown did. So the argument that there is no findings, while there are not a lot, because it's only 4 bullet points, when you pick up the decision from the planning board, the findings of fact, you will in fact read that, and that is a finding of fact. That planning boards and boards of appeals are not professional boards in the sense of like an administrative agency or, a judicial panel where that's their job that they get paid for. And so you're not gonna get the perfect set of factual findings. It probably, more often than not, because you're going through it, you're analyzing it. The record makes clear, based on the questions from the planning board, that they were thinking about these issues, and the decision makes clear that they made a finding that it was not practical to put a class 3 buffer anywhere else. And that, given the legislative history, the sort of fundamental fairness of how we got back to the planning board and now back here again, the fact that the abutters, no abutter has objected to it, and in fact are in approval of the project, all support that the waiver was a valid waiver and that this board should uphold the planning board's decision. So, wordy, I know, I apologize, but I can answer any question. Similar, as to Energy North, any questions?
I think that you probably should open up the opportunity for public comments.
I was going to do that.
And then give each party an opportunity to respond, and then I'll go up and do my piece.
Okay. Do we have any abutters present that would like to make a public comment, since they were referenced in the previous presentation? Please state your name.
Name's Scott McConkey. I'm the one that's right next door to him, which my family owned the whole place originally. Started the gas station in '58. I'm 100% behind what Sam Brown's doing. We looked everything over, and they've even gone beyond putting up to make sure for sound, everything. So I'm hoping that we can get this going soon and get rid of what's there.
Okay.
Okay?
Anybody else?
I'm Diane Monaco, and I'm a real estate agent here in town. I have a client who is a neighbor of this property, and her biggest concern is the buffer and how that's going to affect Fairhaven, which is the road right next to this property. The problem for her is, how do we even present this if we're going to sell it? It is no longer going to be on the Crooked River, very quiet area. I don't know what kind of a buffer or how big that buffer is going to be, that it's not going to impact the sale of that property and all the others there. The only other comment that I have is the gentleman mentioned that there wasn't much of an impact statement from the abutters. She's here in the summer. So 3 of your meetings, she couldn't have attended to begin with, to just talk about
Or
these
the
issues.
meetings are available virtually, right?
Yeah, they are.
Yeah.
But she's in Florida.
We have somebody logged in right now.
Yeah, see Martina.
Yeah,
Wentz is
same
in-
one. Yeah, so
Yeah.
just her thoughts.
That was going to be my question, is if they presented their concerns during, because certainly the planning board has had multiple meetings on this, and
Yeah.
would have been happy to address that. I'm sure C.M. Brown would have been happy to address it. I feel the pain, but I understand. Okay.
They're all just quiet people trying to figure out whether they can enjoy their property.
Yeah,
Okay, thanks.
okay. Then, anybody else? Any other abutters?
And
Public.
any members of the public.
Any members of the public? Being none, the floor is yours.
I think we should give the parties an opportunity to rebut.
Good suggestion.
We're almost there.
Good. Go ahead.
Thank you. I just want to address a few comments that C.M. Brown's attorney made on the buffer requirement alone. There was a lot of comment that this board almost made an error when they reversed the decision of the planning board. We don't see that. And there was also mention of the 80B appeal process and everything that's going on with the court. That is not the concern of this board here tonight. We're reviewing an appeal of the site plan approval that happened in April. That's it. We don't have to consider any motions to dismiss or any thing along those lines that were heard by the court. This board was explicit when it reversed the decision of the planning board. What C.N. Brown's attorney said, oh, it might have been supposed to be a remand. That is not what happened. So what happened is it was a complete final decision by this board to reverse that decision. There is a new application that came in with new requirements. That buffer requirement is a requirement. Just because they had a site plan that was in place beforehand that worked under the old ordinance, that does not mean the standard does not apply to the newly submitted application. And that's exactly what it was. It was a newly submitted application that is subject to different rules. The purpose of this rule is clear. You want a buffer between commercial and residential uses. You heard a comment just now that there is concern. There's typically concern when a commercial development goes in next to a residential use. The town must have considered this. That's why they said a 25-foot buffer is just not enough. Just because it doesn't work for them and they thought they had an approval that this board clearly said was reversed, they can't go back and say, okay, your decision of reversing that approval, now they are inconvenienced. And that's what they're saying. There was financial burdens, the old site worked for them. That's exactly what he just said to this board. It was a bit long-winded the way he said it. Yes, there are concerns. One abutter did come up and say that he's okay with the project. There's other abutters that aren't. The board may have heard one abutter say that they don't mind. Well, you hear tonight other abutters aren't. This waiver should never have been granted. Their financial burden on complying with the ordinance is not an unnecessary burden on them. There's not a special circumstance here. That's exactly what would have to have been found. Them coming up and saying they can't design a new site, not even a new site, just implement a slightly bigger buffer so the people behind them can have a good buffer, have a 50-foot buffer so they don't have to live next to a gas station. That is not a burden that is unnecessary, too substantial, and they simply don't meet the waiver requirement. Thank you. And just to reiterate, that's exactly what applies, that buffer requirement. It was not a remand to the board and a pending application. It was a final decision and a new application submitted that is subject to that buffering requirement. It doesn't matter how they try and paint it, that it was a remand, it was not.
I will just say, it's waivable, and that's what was done. And I guess I would say, in taking everything you've heard today into consideration before you make a vote, I don't see that we're trying to paint anything in any way other than the experience we've lived. Yet what I've heard today was some argument at the beginning that there was not a final decision for the purposes of the res judicata argument I made, which maybe you'll forget that word after you leave here, it's silly. But what I just heard now, I wrote it down in quotes. It was a complete final decision. I don't know what that's worth to you, but when we stand up at the beginning and say you can't apply these legal principles to us because it wasn't final, and then your last comment almost is it was a complete final decision, I think that should bleed into the understanding of the actual merits of this case and not the business competition reasons for which we've been here twice. Thank you.
I would say that the board already made a vote that there is res judicata on those issues. We're talking about a different issue, the buffer issue.
All right. So two things to go through. The driveway width and the class 3 buffer. And so let's just start with the driveway width, and maybe I'll give you my take, and then you guys can do a vote, and then we'll go to the buffer. So the driveway width, I more or less agree with what CN Brown said on the driveway width. So if you recall, the last time this came up, there was an argument that the planning board erred by not applying the stricter requirement, which was in the ordinance, the 40-foot requirement, and that was what this board reversed on, and it was a straight reversal. They went back, and they met that 40-foot requirement. They now have a Maine DOT permit, which says that, which indicates that the DOT has decided not to apply that other standard that they would have applied. And that DOT standard is waivable, which was the whole basis of the decision the first time, is that DOT has discretion to waive those standards. So the planning board doesn't need to apply a stricter standard that it doesn't know is actually going to apply. So on the driveway width, I think the bottom line is, they've met the ordinance requirement. The record shows that they brought it down to 40 feet, and that's what the ordinance requires, and I think that's what's consistent with your past decision. Any questions on that?
So do we vote on that right now? So you just said
You
we'll vote
can,
on
yeah,
that right now?
yeah. That might help for keeping things,
Yeah.
but I'll leave that to the
So
chair.
what's the
to decide.
wording of the vote here? How do we word this so we can vote on it? We approve the 40-foot, we approve the 40-foot width, okay.
Well, that we either approve or deny
Right.
item number 7 in the appeal,
Yeah.
which is.
Item number 3 is the width. We're talking about the width right now, right?
Yes,
Yeah,
item
not
number 3.
I beg your pardon.
Item number
Yes.
3.
Yep, so if you want to make a motion.
I approve of the 40-foot width.
Yeah, I know you did,
Make a
but you
motion to approve the 40-foot width.
Can I suggest motion language?
Go ahead.
So your motion would be move
Move, right.
to deny
Deny item number.
point number 3 in Energy North's appeal.
Okay. I move to deny item number 3 from Energy North.
Do we have a second?
Second.
Any further discussion by the board?
None?
Any further discussion? Okay. Can we have a vote, please? All those in favor of his motion? So 3-0.
All right. Last item, class 3 buffer standards.
Number
So,
7.
item number 7. So there's kind of 2, maybe 3 issues here. And so just to kind of recap what happened, the planning board voted to waive the class 3 buffer requirement. And so that, they're challenging that waiver, whether that waiver was proper. And CN Brown has raised, I think, a second argument that that standard didn't need to apply at all in the first instance. So just going through the waiver piece, there are specific requirements in the ordinance when the planning board grants a waiver. They have to make specific findings. They made those findings, so I think you can look at those findings and decide if they are adequate. So that would be on page 2 of the planning board's decision, which is attached to Energy North's appeal.
Yep. Page 2. Page 2?
You have my glasses.
It's page 2 of Exhibit C of Energy North's appeal.
Exhibit C. There you go. Page 2. Okay.
So,
Page 2, item,
item 3, I think, move to
Yeah,
waive
it
the
is.
requirements of the Class 3 buffered standard and allow Class 2
Yep.
buffered as depicted. And so they made 5 findings here.
yep.
And the question for the board is whether those findings meet the requirements of section 905 of the ordinance. So they have to relate to whether there's an adverse effect on the neighborhood, whether the purposes of site plan review are met, whether the scale or nature of the project is of a size that makes the information necessary, and whether there are special circumstances of the site that make compliance with the specific application requirements or standards an unnecessary burden upon the applicant, as long as such waiver will not adversely affect the abutting landowners and the general health, safety, and welfare of the town.
Well, I guess my only question would be on number E. They were not aware of the concern by one of the abutters, because, right, because they did not attend the meeting, did not voice those.
Yeah, and I don't know what the record would say on whether those concerns were raised below, at the planning board.
Can I address that?
Yeah, do you mind?
There were no such concerns. There were no such concerns presented at the planning board hearing
Right.
on April 15th. And the woman that spoke today, I believe, is also not actually an abutter, but was speaking on behalf of some other abutters, just to clear that up.
There's also my understanding the neighborhood that she was talking about, is that still in a commercial zone?
Yeah, so that's the kind of secondary argument that I think C.N. Brown is raising, which is what the ordinance actually requires is a buffer between the commercial properties in the commercial district and properties in the residential district.
Right.
And they provided a little bit of legislative history about that, which I think is interesting and compelling. Let me just pull up the language here. I think the language also kind of supports this interpretation. So it says the planning board may require buffer zones between commercial properties where the difference in use of the property as a natural feature make the properties or buffers appropriate. That seems to consider, properties within the commercial zone, that it's optional within the commercial zone. So basically, the interpretation that C.N. Brown is offering is a Class 3 buffer required between commercial and residential properties means a Class 3 buffer between the properties that are zoned commercial and the properties that are zoned residential.
Right.
Frankly, as your attorney, I think it's colorable either way, and I think we can defend it either way. So I would leave that to your judgment. The one other issue that I wanted to address, and this was raised in Energy North's memo, but I don't think they actually talked about it tonight, but I think it has been raised, so I think we should address it. Any standard that applies in a particular zone, but not in another particular zone, can't be waived by the planning board, because it's a zoning standard. And that's how the courts have always interpreted that, so it means that somebody has to come to you guys and get a variance before they can waive it. So I think if you find that the Class 3 buffer standard does apply here, I think the planning board probably didn't have authority to waive it. Because of that rule of law. But if you find that it doesn't apply, there's no need for a waiver. And so those are kind of your options, I think. It really comes down to, do you think this applies just between residential and commercial property, just between the residential and commercial zone,
Right.
or just between residential and commercial uses? And it's, I think, vague on that point.
I guess my thought was, there's a certain expectation if you're commercial and residential about what might be built on the commercial if you're a residential owner. But if it's a commercial property, sooner or later, something is going to be going in, and it was a convenience store at one time. It was a gas station at one time.
So the buffer
Yep.
was approved by the planning board was for Class 2, correct?
I think it's a mix of Class 2
Class 2 and 3.
And 3?
Yeah, where they
So
could, they did
there were
too.
areas where they could meet the Class 3, but not all the areas.
Yeah.
Okay.
Russ, do you have any questions? Comments?
You cover them all.
What's that?
I said, you cover them.
All right, it's in your hands.
Thanks.
So what are we voting on here now?
This is number 7.
Yep. Got that.
So whether or not the planning board met the threshold for the class 2 and 3 mixture of buffers there, correct?
So it doesn't have to meet the class 3 for the entire property. It's just areas where they could meet class 3, they did, and the planning board understood that, and they
So-
approved it based on that?
The buffer requirement says that in the commercial zone, a class 3 buffer shall be required between commercial and residential properties using plantings or screening methods, as shall be reasonably required to prevent the commercial use from being incongruous with the existing or contemplated environments and surrounding properties. The planning board may require buffer zones between commercial properties where the difference in the use of the properties and the natural features of the properties makes buffers appropriate. All buffers and screening must be maintained indefinitely by the property owner. So the planning board waived that requirement. If you believe that that requirement should have applied here, that waiver was probably not appropriate, because it only applies in the commercial zone and is therefore a zoning requirement. If you think that what this is really saying is that it only applies between the commercial and the residential zone, then there's no need to waive it in the first instance because it doesn't apply here. So if option A, you would affirm the appeal, that would be grounds for reversal. If option B, you would deny the appeal because there was no need to grant a waiver in the first instance. It's basically what we call harmless error. They got it right for the wrong reason. Does that make sense?
Kind of.
So if you deny the appeal, we deny the appeal, then we're accepting all these, basically, so you're saying?
Yeah, if you deny the appeal, the planning board's decision stands.
Yeah.
Yeah.
They have questions for the planning board. We do have the vice chair who's standing by to answer any planning board questions. Martina is the vice chair, and she's
What's
standing
that?
by.
Martina Witz is here.
Martina Witz is via Zoom if you had any questions
Yeah,
for the planning board.
she's on the planning board.
She's the vice chair.
You have any questions for Martina? Martina, are you there?
Yeah, she's logging in. Oh, she's trying to talk right now.
Do you have any questions for Martina?
I don't think so.
Can't hear her.
Feel good?
You
I
want to
can
make?
see it moving, but I can't hear her.
Let me see if we can. Let's try that.
Martina?
Confused.
Yep,
There she is.
Going on.
There's Martina if you have questions for Martina.
I'm sorry, I'm not gonna put the video on because I'm having trouble with both the video and the audio at the same time.
It's okay. Do you guys have questions?
We're discussing the buffer zone, Martina, and from the notes of your meeting, number 4, a combination of Class 2 buffer and Class 3 buffer as depicted on the site plan improve the current buffering and will not adversely affect the abutting landowners or impact the general health, safety, and welfare of the town. We did have a representative from one of the abutters say that they had not spoken at the planning board meetings at their seasonal, and so just was wondering the thought process behind number E.
Sure. So, as I'm sure you're all aware, this has been a months and months long process on this particular application. So it's unfortunate that anyone didn't have an opportunity to speak during those many months. Of all the parties represented in this particular situation, I'd like the appeals board to understand that the planning board is the one party that really took into consideration what was best for the town. I mean, after all, that is our charge. And I guess I don't have to state the obvious, but I will, but that all the other parties there have their own particular interests at hand. So having said that, I would like the planning board to be assured that, I'd like the appeals board to be assured that the planning board took this very seriously and took everything into consideration. And when it came back to us a second time, and that new ordinance came into play with the buffer, we did look at that very seriously. And looking at the entire plan with the other adjustments that C.N. Brown had made, we felt, and I still believe today, that we made the right decision in saying that buffer was not necessarily best for that site. So, well, that took into consideration all the stormwater treatments that were going to happen there and the other plantings that were going on the site. So, we took it all into consideration and we were very serious about it, and that's why we came down to the conclusion that we came down to.
And that was a 5-0 vote.
I don't have that number in front of me,
Says it
but
right
if
here.
that's
Yeah,
what the document
I guess that's more of a statement than a question. It was a 5-0 vote.
Yes.
Okay, yeah, okay.
All right.
So I don't know if that helps, or if that answers your question.
David?
So what's the motion that we, if I want to move to accept the planning board's decision to waive,
That would be to deny item number 7.
deny item number 7?
Not number 7 for the buff.
So I'm making a motion to deny the appeal for item number 7?
Good motion language.
Okay, we move to,
Yes, it would be number 7. Is that your motion?
yes.
Deny the appeal for item
Yes,
number 7,
to
which is the
deny the
planning
appeal.
board erred in waiving Class 3 buffer requirements.
Right.
Russ? Yeah, second.
Second.
A vote,
Okay.
3-0. Okay. I think that concludes the discussion of the appeal public hearing. Are there any other Board of Appeals businesses items? No. Okay, need a motion to adjourn?
I move to adjourn the meeting?
Second.
Let's go have some ice cream.